Beautiful people, it's me, Pamela, on my YouTube. Cho, no, what's the T? Siyahlaziya.
The fact that Baloyi can't get through Muzi Sibiya, it stresses him so much. He doesn't know what to do. Basically, the statements again, Baloyi will be reading the statements again the whole day, guys. Why? Because there's nothing there. You've tried it for a week, reading the statements. No, I didn't have a card. Umbali, my girlfriend, had the card. And uthi manje niphila kanjani wena nombali? Beniphila kanjani ngoba you have no money. You know? Ngobani also imali le ekuthiwa uKelly is the mastermind. Ayibonakali phela ifakiwe. Fanele sibonakali phela leyo mali leyo. There's just 14,000 from SARS. Another time there was another year actually. There was another 60,000 rands from SARS. Guys, there's nothing that you're going to get because in the end, whatever happens, these guys did not analyze sense. This was important. You can read all the statements in the world. Ratha was now contradicting himself about Zungu when he actually used Zungu's evidence to rule around 174. Ganxa Malube no accused number 4. Manje futhi Chiki said, I know also Zungu's evidence was just an individual evidence. Guys, I mean, Absalom must come now. We are ready. No Uzungu must also come to retract all that crap that he told the court, the evidence akuyamanga. Phela guys, awazasindawo la. Ngapho uBaloyi na ubhizi usebenzisa izinto zika accused number 2 isenza accused number 1. Ubicabanga ukuthi uRatha uzomiyeka. And uRatha manje is just like, you know what? Phela can't take everything you say. And obviously, I mean, you know how it is with Ratha, how he speaks to the states, or should I say Baloyi nje on his own with the defense. The tone is normally not the same. Ukuyibona leyo nto leyo ngizoye ngime lapho guys kuSenzi Meyiwa. Saqhubeka indaba yalomsangano nakuleya court.
It was a little discomfort.
Is he okay now?
He indicated that we may proceed, but because
maybe it's not okay, we don't proceed. We don't want people to proceed.
No, he is okay.
They say he's not okay. He'll try.
He is okay.
He's okay. Okay.
Yes, my lord. But let me just request, because that is got to do with the tummy. So there might be circumstances where we request a short adjournment.
Okay.
But all in all, he indicated that is okay, my lord.
And then after, the whole defense team addressed me.
Inkantolo kuyasho ukuthi ngoLwesihlanu ke wesonto elindlule ukukhona ke udaba la khona umnumzana uBaloyi omele ithimba labashushisi bekaqhamukisa ngoba bekaveza ke ukuthi akubuzeke imibuzo eSotobe mayelana nestatement esenziwa umnumzana wesibili umfokantanzi mayelana nestatement sakhe sokuvuma amacala i-confession ke ngesingisi bese ke inkantolo yabuza ukuthi ngabe kuvumelekile yini lokho ngokwezomthetho bese umnumzana uBaloyi wathi yebo watshela inkosi yenkantolo ukuthi lokho kuvumeleke kanjani ke bese ngemuva kwalokho nabameli beno nabo bonkana bakhuluma bese batshela inkantolo ukuthi lokho kuvumeleke mhlawumbe kuvumelekile ngendlela ekanjani.
Yeah. I researched a bit and I found the case of Mhlongo. I think it is applicable here because in the Constitutional Court, in that appeal, the defense raised two constitutional issues that the circumstances surrounding the cross-examination of those two accused was not fair because it transgressed or contravened Section 9 of the Constitution, which guarantees that an accused should be accorded, or all accused in a trial, even the witnesses of the state, should be accorded fairness. They mustn't be treated unequally. And further, that Section 35F of the Constitution was being transgressed because it deprives accused number 2 the unfettered right to give evidence. We must remember, he hasn't given evidence. And he also has the right to challenge evidence, even the evidence, if he wants to, of accused number 1. So that right remains unfettered. And what has happened in this case, Mr. Baloyi has already cross-examined accused number 1 regarding the so-called confession or extracurricular statement he made. And this court, you'll recall, all I did was to make a ruling that the statement made by Mr. Sibiya. Is it Sibiya?
Sibiya.
Sorry, I'm sorry. It's not the status of that statement has not been definitively defined by this court as a confession or as an extracurricular statement. Mr. Baloyi calls it an executive statement. Because what has happened is, normally a confession, State versus Bartman, I think 1929, defines it as an unequivocal admission of guilt. But if you look at the statements made by Mr. Sibiya and Mr. Ntanzi, they are not unequivocal admissions of guilt. An unequivocal admission of guilt is where a person makes a statement and admits all the elements of the offense. Like saying, I killed Ratha and burned his body. But in this matter, which we are having, we have not yet, as I say, made a definitive statement to the status of the statements, what they are, as from the court's perspective. This very issue was transgressed and debated in the case of Oswald John Mhlongo and the state, and Alfred Disco Nkosi and the state. I'll just read the law as expounded by the Constitutional Court. Equality before the law, that is Section 9 of the Constitution. It was contended by the applicants that the distinction drawn by Ndlovu between admissions and confessions effectively leads to indirect differential treatment between groups of accused persons. Those implicated by an admission on the one hand and a confession on the other. A confession is inadmissible against another person, while according to Ndlovu, an admission may be admissible. We all know that Ndlovu was set aside. It violates Section 9(1) of the Constitution, which provides that everyone is equal before the law and entitled to equal protection and benefit of the law. The distinction between the confession and admissions is determined solely by the extent to which the statement implicates its maker. This distinction becomes relevant in determining the safeguards that are put in place to ensure the voluntariness of the confession or admission. If a confession can be used with little more to secure the conviction of its maker, as opposed to an admission which would still require the state to prove various elements of the crime, then there may be logic in applying more stringent requirements on its admission against that accused. The distinction apparent in the difference between Section 217 and 219A of the current CPA. However, the distinction has nothing to do with a third party. Accordingly, there is no rational reason why, when used against another person, there should be a difference in the admissibility of the two types of statement. The Supreme Court of Appeal in the case of Litago said the following: from the perspective of one accused who may be implicated in the statement of another, one strains to discern a sound jurisprudential basis for the distinction